Hey, it's Jen McCaskill. We are talking today about modification of support. Modification of alimony and or child support. If you have alimony and child support obligation, and the modification of one will affect everything. Or actually, the modification of alimony will also affect the modification of child support. In order to have a modification, or in order to make an application for modification of support, you have to have experienced what is termed as a substantial change in circumstances. Also, you have to show that the change in circumstances is permanent and not temporary. And all of this is governed by this case called Lepis v. Lepis. You can Google it if you want to put yourself to sleep and read some case law. So here we go. Somebody comes to me and they say, Jen, I lost my job last week. Therefore, I can't pay alimony. And I have to pay less alimony. I have to pay less child support. I don't have any money. I don't have a job. Well, first of all, it can't be I lost my job last week. It really has to be that I've had at least 90 days, according to the statute, of a substantial change in circumstances, and those circumstances are permanent in nature. So a temporary layoff or even a layoff or getting fired does not automatically give you the opportunity to downwardly modify your alimony and or child support obligation. So let's use the example that I see most often, which is I get laid off. So let's say husband and wife are married, they get divorced, husband's making $200,000 a year and he's paying alimony and child support based off of $200,000 a year. He loses his job. He is 62 years old, cannot find another job for $200,000, ends up finding another job for $125,000 a year. Again, it's not so simple that he just files a motion to say, hey, judge, I used to make $200,000 and now I only make $125,000. So reduce my alimony and child support obligation. There's other things that you have to show as part of that application. You have to show that you made a good faith effort to look for a job. That means, I attach spreadsheets of recruiters that were contacted, interviews that somebody went on, networking events they went on, how many people they looked up on LinkedIn. So if you lose your job and you have an alimony and child support obligation, first you need to consult with an attorney to say, what do I do proactively? What kind of evidence are you going to need, Jen, to help me make this application? I'm going to say, keep a spreadsheet, keep a list of every single resume that you've submitted, every job you've applied for, every job interview you went on, because you really have to be able to show that he was making $200,000 a year. He's 62 years old. Nobody's hiring him again for $200,000 a year. He went on 50 interviews, contacted 100 people on LinkedIn, went to networking events, met with 5 different recruiters, et cetera, et cetera, et cetera. The more evidence that you have of your good faith effort to find a job that's comparable in pay, that increases your chances of being able to successfully downwardly modify your support obligation. Because what you can't do is be like, oh yeah, I'm making $200,000 a year and I'm really tired of paying alimony, so I'm going to go get a minimum wage job and I'm going to work at Home Depot for $10 an hour and now I make $20,000 a year. That's it. I don't want to pay any more alimony. So the law does not work that way, because there's something called voluntary unemployment or voluntary underemployment, meaning that you have the ability to make $200,000, but you're voluntarily choosing to make $20,000 just to try to get out of your alimony obligation. That is not going to work. The judge is going to get pissed off at you, and you're going to get smacked with counsel fees, depending upon how much you annoy the judge for wasting his or her time to even argue such a nonsense motion. So in order to modify your support obligation, and your support obligation is always modifiable, assuming that your agreement doesn't say otherwise, that you can't modify the alimony obligation. Child support is always modifiable. but let's assume your agreement doesn't say that. It is always modifiable, the amount that you pay. But again, you have to genuinely have experienced a substantial change in financial circumstances. And again, the analysis isn't going to stop there. You're really going to have to prove to the judge that this is in good faith, that you're not just being an asshole and trying to voluntarily reduce your income so you can therefore not pay your ex anymore because you're so pissed about the divorce and you feel like you got screwed. That's the basic on modifying your support obligation. As always, if you have any questions, feel free to call me.